face it, today I'm going to be mostly lecturing, so take notes. Stop me whenever you want. I might tell you I'm going to get to that, but I may answer you right away. And also, if you want, I know, for example, Joe said he was going to be here today. If any of you go to my faculty website within 24 hours after this class, go to Juvenile Law Online, and you can access the audio of our class. I mean, it's a good way for you guys to review, too, if you wanted to. Okay, and it's available.
When did that go up? Because I tried it once in the beginning.
Yeah, it's always within 24 hours afterwards. And you just click on it and get the audio. Yeah.
Just when I was reading the stuff on the CD, is this the current law? Because like I no longer saw a child in need of services. They had different definitions.
Later on, we're doing the care and protection process for probably the next about 4 weeks. What used to be CHINS that we will get to later on that deals with children that have run away, have disobeyed at school, at home, or who are truant. There was new legislation about a year ago, and it's child requiring assistance rather than CHINS. But the basis for them getting into court is the same. Okay. So what I put on the board is, and I'll be going back and forth. Unfortunately, you know, Chapter 119 is one of the most poorly written statutes you'll ever read, and they keep changing it and reorganizing it. And I'm going to jump around in terms of the statute. For example, the way I gave it to you was obviously consecutively like a statute, 119.1 and so forth. And midway through, you actually see 51A and 51B, which is where I'm going to start, because those sections deal with how the state may get a report of abuse and neglect, what the state's duties and responsibilities are, and what services they offer and so forth. Whereas some of the earliest sections, like the definitional sections 21, 24 deals with the initiation of a care and protection petition in juvenile court, as well as the trial, the disposition, the reviews, and all of that are, again, consecutively before 51A and 51B. But I'm going to start here because, again, you need to start with the agency involvement in the case. Now, I say the case, but think of this way. The Department of Children and Families, by the way, a lot of your cases, in fact, that article that I gave you, that's a fairly old article, but I think it explains the procedures nicely. Talks about the Department of Social Services. That actually was renamed with another amendment to the statute, I think 3 years ago, around 3 years ago. So it's DCF, but you'll see DSS, and actually in very early cases, you'll see it named the Department of Public, DPW, Public Welfare. DSS came about somewhere in the early 80s, and then again, 2000, we're now in 2012, 2009 or 10, it became the Department of Children and Families. The other thing that you don't have in terms of authority, and I'll refer you to some of the actual sections of DCF's regulations. All of their regulations are contained at 110 CMR, Code of Mass Regulations. I'll refer to some of them today when we define what abuse is, what neglect is, for example, emotional abuse, and some of the other sections. So we have, like, when we're studying, in particular, when we're studying abuse and neglect cases in Massachusetts, we have the 3 kinds of primary authority that we're dealing with. We have the regulations, which is, we have DCF as an agency, which is administrative law. So as an agency, it promulgates its own regulations, that's CMR, but it also can sit as a quasi-judicial hearing board. So for example, we'll talk about, when DCF makes any of these determinations along the way, parents, families, children, they're entitled to fair hearings under the Administrative Procedure Act in Massachusetts, Chapter 30A. So you have administrative law, then you have statutory law, which is mainly 119, 210 as well, some other statutes that deal from next week when we get into the sexual abuse. There are out-of-court statements in 230, chapter 233 somewhere. So anyway, we deal with statutory law, and lastly, we deal with case law. The first 3 weeks was sort of an introduction to the family rights, the constitutional rights, but we're now also going to get into the SJC case, the cases in Massachusetts. So case law, statutory law, and administrative law all play are major players here. Whether you represent, families, parents, or the state in any of these cases. Later on, we also will get into, and you'll see it a little bit when you look at the statute. I'm mentioning DCF, which is a civil agency dealing with children. Section 1 of your statute says that the agency was created to, strengthen and encourage family life. Its own regulations that start at 110 CMR, I believe. Section 1, the first part of the section also uses that same terminology, but it talks about that DCF has this dual obligation that can sometimes be at opposites. Anybody know what the dual obligation of the state might be in these cases when you're dealing with families with children? Cassandra?
To protect the best interest of the child.
So protect children,
right,
and?
But then reunite,
You're
kind
saying
of reunite.
To help families, to
help
reunite,
families,
to
right.
strengthen family, to offer services. So on the one hand, protecting children from abuse and neglect, intervening, remember, so we studied those earlier cases where you guys that were parental advocates said, the state shouldn't be involved. We have, as parents, we have the right to say where our kids should go to school, what language they should learn, etc. So, but remember when you read Prince v. Max, the state has the right to intervene when there's some sort of danger in terms of the physical welfare, emotional welfare of children. But at the same time, DCF also has sometimes the opposing obligation to help families, so that, as Cassandra said, so they can be reunited. So that's section 1 of the statute. It's also the very first regulation that DCF has. So how does DCF get involved with families? Well, it usually starts with a report. And all 51A is, and if you have your statute with you, you can you can look at it, or you can just take notes. So if you go to 51A, it actually starts with defining what a mandated reporter is, right? Actually, the definition is in section 21 of the mandated reporter. If you guys looked at, did you get a chance to, and I know there are lots of sections of the statute, so I'm going to highlight the most important sections today. I'm not going to go through section by section of the entire statute. As we get to the case law, we'll come back to some of those sections as well. So section 21, which I didn't put on, contains a bunch of definitions as well. Yes.
No, did you say section 21?
Yes. Am I right, or is it 21A? No, it's 21.
21A is admissibility
Yeah.
of evidence.
If you look at section 21, the term mandated reporter is 51A report, child advocate, commissioner, custody department, then mandated reporter is defined.
No, this is in Mass General Law 71.
No, 119.21.
Thank you.
We're dealing with just 119 right now. I'll tell you when we'll deal with 210, which deals with termination of parental rights, and that's like the worst case scenario. By the way, the definition of mandated reporter was actually, I thought, a pretty good amendment of the statute. 51A used to contain this really long sentence that included like all the mandated reporters. as the subject of the sentence. And I mean, look, it's probably at least 18 to 20 lines, and then it said in the professional capacity, blah, blah, blah. So what the legislature did was took the term mandated reporter as defined out of 51A and put it in section 21 and said, okay, we're going to define it first, and then when we get to 51A, then we're going to talk about what the mandated reporter's duties and responsibilities are. But first tell me, who are the mandated reporters, just generally, sort of by category? Richard?
Police officers, firefighters, school teachers, hospital personnel, EMTs.
Yeah. So I like to think in sort of four categories. So you have medical, law enforcement, school, anything, and that includes, babysitters, nannies, etc., daycares, etc. And the last category was by an amendment of the statute in probably the early 90s, the clergy are involved as mandated reporters. So when we go to 50, go ahead. You were going to raise your hand.
Yeah, I thought it was interesting when I read this, and I probably overlooked it, but I would think the school bus driver should be in there too, because they see a lot that the teacher or the principal doesn't see.
They'd be considered school personnel if they
Yeah,
go for the
and they
school
probably
department.
are in that category. Yeah, so I agree with you. School bus drivers see something, they should be mandated, coach. I don't want to get into that whole scandal and court action. Maybe we'll deal with that as a hypothetical sometime. So 51A, so mandated reporter. Suppose it's a school teacher, okay? You're a 6th grade teacher. Child keeps, coming to school with, 6th grade is how old?
12, 13.
About 11?
11 to 12.
12, 13.
Okay, let's make them younger. 4th grade is about 9 or 10, right?
Right.
Okay, so they're coming, you have a child, her name is Allie, and observable bruises over a period of, say, 30 days, different parts that you can see. And very quiet in school, shy, doesn't herself disclose, but after, maybe you questioned her once and she said she fell off her bike or something like that. Maybe you asked her, oh, what happened today? I tripped. And maybe the 3rd time she says, I want to make it a little bit of gray. She said, well, I was bad and I got a spanking. She doesn't disclose who it is. I was bad and I got a spanking. What are your responsibilities as a man? Richard mentioned you're a mandated reporter, so you fall within that class.
Well, as a teacher, you have to report to your next supervisor.
Well, but before you make the decision to report, let's look at what the test for you is, what the standard for you is under the statute. Okay, and actually, let me read to you guys, because you don't have the CMR. Let me read you the definition of abuse, if I can read my own writing. Okay. Abuse. And this is 110 CMR 2.0, contains definitions that are more exclusive of the definitions that are contained in the statute 1921. So DCF defines abuse in its regulations, and here it is. It's the non-accidental commission of an act. I'll repeat it too if you guys want to write it down, or you can look it up. The non-accidental commission of an act. By the way, these definitions are also contained in that article that I gave you by the elder, of an act by a caretaker causing a substantial risk of, and I'm not giving it to you word for word, these are just my notes, okay? So you can look at the actual definition. But it's a substantial risk of physical, emotional, sexual harm. So that's abuse. Non-accidental commission of an act by a caretaker. Notice that I'm stressing that word. John?
Yeah,
Because that's like one of the first parts of the screening process.
Okay, yeah,
is-
don't jump ahead to the screening process yet, but what is a caretaker?
A caretaker would be a parent or a guardian.
Daycare.
Or, whoever is in the care, the child is in the care of that person. Now, let me ask you all a question. Does the mandated reporter, or the reporter, for all purposes, need to know who the caretaker is in order to be bound to report suspected instance of abuse and neglect? Jadida said no first, so let me go to you.
I said no. As long as they see signs of abuse there.
And again, what's the sign?
Again, the signs are substantial risk of physical, emotional, or sexual harm.
So go to the very beginning of 51A, and there's the standard right there. And you're going to see this standard everywhere in other parts of the statute, in case law. And I've got it up on the board. Reasonable cause. Reasonable cause to believe, right? And if it's a mandated reporter, it's in your professional capacity, right?
Yes.
Reasonable cause to believe that a child is suffering physical or emotional injury resulting from, and there were a few instances as defined in the statute: abuse, neglect, the addictive drug at birth, being physically dependent. Okay. So, yeah, so you want to follow up on that, Jadida?
Oh, I actually had a question based on the hypo that you gave.
Mm-hmm.
Now, let's say, as a teacher, I see this child tell me, I got a spanking because I was bad. And this is the first time I've seen this.
Yeah, that's why I deliberately made this one gray. Go ahead.
So now this is the first time I've seen this. Do I report that right away, or do I, or do I wait?
Well, let's put it this way. Are you mandated to report it right away under the reasonable
because I don't think
cause
that's reasonable.
standard?
I don't think that's a reasonable cause of standard.
So how would you vary, Cassandra?
But it's still important to document it. Like even
Sure.
if it's still, so that when, let's just say, the next situation occurs and it is serious, oh well, then I do remember the child being spanked last week for such issues, but I don't think that it rises to the level of reasonable.
The article that I gave you has an old appeals court case cited in it, Mattingly versus Casey. Really sad case. A schoolgirl that, was over a period of time going to school, with bruises, etc. And her parents were divorced, so she was living with a step parent and bio parent, and I forgot which was which. And there were at times 51A reports that got dropped. Ultimately, the parent in the home beat her so badly that she ended up she was in a coma, and then I don't know if she was in a vegetative state, but really horrible injuries. Well, the other parent, the non-custodial parent, sued the state, the school, sued pretty much all of the,
Mandated reporters.
Exactly. And it was, the decision came out before the Mass Tort Claims Act. You can sue the state, but the ceiling, unless you're doing a 1983 and a civil rights action, but the ceiling when you're suing the state actors, even if you win, is $100,000. But anyway, it was before the Tort Claims Act, and the appeals court said in its opinion, in dismissing the claim, basically said something to this effect: not every bruise has to be reported. And yes, it's a true factual statement, but when, the question is when, in the hypo that I gave you, yes, it's a gray area. Suppose the girl goes home, after she says, I got spanked, and then it might be too late. The spanking might result in, serious injury or death. So the reasonable cause standard that you will see, and you will see it in the C&P process as well, is a very low threshold. Along with that, You can't be prosecuted or fined, etc., if you make a report. You know, that's a serious report that's not frivolous. So you keep that in mind, Patricia.
So in terms of teaching, though, if you just report, I've done this, if I had any concern at all, I just report it to my principal.
Exactly.
And then
exactly.
the responsibility is off me. I've done what I need to do.
You've done, yeah.
And many times what she would do is she'd just hold them until she thought that she convinced herself that there was an issue.
Exactly.
And she erred on the side of caution, and she was always pretty good at it. So.
Yes. Now, there was somewhere that I also wanted to bring your attention to another part of the CMR that actually defines physical injury. A is death, obviously. B is fracture, subdural hematoma, burns, but then it also says non-trivial injury. So what is that? C is soft tissue swelling, skin bruising, exactly what I just gave you. But it also says depending on the child's age, circumstances, etc. And then D is the drug addiction at birth, and then E is failure to thrive. So again, the regulations define they also define neglect. We'll get to that, but they define physical injury. So let's just go with that. It does get reported, all right? In what sort of instances would a screen out occur? And what exactly is a screen out, if anybody knows? Richard?
Where when you call in 51A, they may screen it out before they even really investigate it. If you say it's not a caretaker.
Yeah, and that's the most obvious example. Say the girl was actually dating age, and she was your student, and she said, my boyfriend hit me. Okay. Obviously, that might be within the parameters of the district attorney's office, but it's certainly not DCF's responsibility, so it would be screened out. So that's just one example. Multiple, reports are sometimes screened out. We already have it, that sort of thing. It's screened out, it just ends. Nothing further happens. It's once it's screened in that the duties of DCF kicks in. So all 51A is just the reporting procedure by mandated reporters and by others. That's all it is. It's just the report itself. 51B is all about what DCF does after it gets the reports. So it could be screened in, and notice I've got on the board as an emergency or a non-emergency. So let's take the emergency first. Actually, we're going to read some cases for Thursday. Next Tuesday, we're doing domestic violence, and after that, child sexual abuse. So those are pretty serious circumstances. Suppose that the police got called to a domestic, incident. Husband and wife are, fighting, and when they get there, they see that there are children in the house as well. Husband is about to get arrested, and wife has some, pretty serious injuries. Also, in looking around the home, police see that there's a 3-year-old and a 5-year-old, and they're huddled in, one of the bedrooms. The 5-year-old is, nurturing, protecting, hugging, whatever, the 3-year-old. Obviously, police are mandated reporters. When they make the call, a situation like that would immediately be screened in as an emergency. That means DCF has to do something pretty much right away. So, within a couple of hours, or hopefully less than that, they're going to get out to the home. Okay, so their investigation is starting right away if it's an emergency. Now, I think I have a definition for you of emergency somewhere. And again, that's in the regulations. No, you know what? They define, and I'll get to that later on, what the the emergency removal is, but they don't really define emergency itself. Unless I can't find it. I actually have it right here. By the way, I meant to point this out. This is MCLE's source book on juvenile law. If you're a practitioner, every spring MCLE will hold its annual child welfare and delinquency law seminar in Boston. And this volume contains the Mass statutes, DCF rules, DYS, CHINs, case law, etc. So I've got the DCF regulations, and I'm going to look again at the definitions. But I don't think emergency is defined in the regs. I could be wrong. Oh, yes, it is. I'm sorry. So emergency means a situation where the failure to take immediate action would place a child at substantial risk of serious and imminent family disruption or death or serious emotional or physical injury.
Can you give that one more time?
Yeah, I will. I was paraphrasing, not to give you too many words to write down. A situation where the failure to take immediate action, and I'm going to say a child, would place the child at substantial risk. So that's the key, substantial risk of serious and imminent emotional or physical injury. So the situation I just described gets screened in as an emergency. Social workers come out to the home as well. Okay. What do you think they're going to do?
Take them away.
Let's take them away. All right, so let's think about this for a moment. It's a Friday night, say. Take them away. And then what, Richard?
Look for an emergency placement. I recently had a similar incident. We were driving down the road, found a 3-year-old in his diaper outside. We stopped, went around the area. Kids in the neighborhood were able to tell me, oh, it's so-and-so's baby. Found her, she was intoxicated, immediately started with DCF. Basically, DCF said they were probably going to be about 2 hours. We called for an ambulance. The ambulance took custody of the child. We started all the paperwork.
Now, DCF also contains in its own regulations that they should be, exploring, again, going to their goal and their purpose, family first. Doesn't always happen. Sometimes in an emergency situation, you might not know who the family is. So children might initially be placed in temporary foster home, but that doesn't discount that DCF still has the responsibility to look into family placement, aunt, relative, sister, etc., if they're available and if they're appropriate. So that's something that later on, when we read the Isaac and Jeremy cases that the SJC decided, that is sometimes the subject of what you hear the defense attorneys sometimes file motions for abuse of discretion. So DCF, being an agency, must follow the law still. Okay? And the law means the regulations, the statutes, the case law. So for example, suppose you represent, mom in a care and protection case, and she says to you, I told them that my sister and brother-in-law lived the next town over, my kids wouldn't be disrupted from school, etc. Yet they put my kids in a foster home 30 miles away. All right, that's again, now DCF has cut under Section 21, and remember I mentioned 21 is all your definitions. Once DCF has custody, and we'll get to that. Once DCF has custody, it's like the parents patriae philosophy we talked about. It's the substitute, parent in in times when the parent is unable and suitable, etc., to care for the child. And custody, one of the definitions of custody is controlling the place of abode. But again, that is not so absolute that they shouldn't be following the law. So motions for abuse of discretion would go before the court, arguing that this agency has abused its own discretion, has not followed, the law in terms of, placement of the child. So anyway, so the children are taken, say on a Friday evening, some sort of emergency, placement, because we just determined it's keeping them in the home right then and there at that point in time is going to subject them to serious injury. Question, Cassandra.
Question: is it this? I know in New York, and I'm wondering, is it the same in Mass? Sometimes when there's a huge amount of kids that are like taken away, or in actually I'm not sure if they go to police or hospital. I don't know if they're in the custody of police officers or in the hospital first, but I know a lot of times there's like this almost like a homeless shelter where there's kids like in waiting for placement. I know that happens in New York. I don't know if it's the same thing.
When
in
you
Mass.
say huge amount,
It's
like
no, I mean,
a family of the family
like,
had 12 kids or something.
No,
or,
like, let's just say on a weekend, a kid is removed, and let's just say there's no family members, there's no contact information or anything like that. Kids in New York would have to go to this. It's like this big warehouse in Manhattan.
Sad.
Yeah, it's really
I
sad.
don't know that DCF has anything like that. I know that sometimes there certainly is a shortage of
Right.
foster homes. And sometimes they're not as appropriate as they should be, or as geographically, blah, blah, blah. But I don't know of any place like you're describing.
Okay.
I'll ask
No,
Chris
it is.
Cook.
It's a huge place in Manhattan where all the kids,
Wow.
they stay there until they can
That's
find a
horrible.
placement for them. Yeah.
In that situation, we called the ambulance because of the weather.
Absolutely.
We wanted them checked out. They went to the hospital. We told DCF responded to the hospital. My understanding is if they don't have an immediate placement, whatever worker goes out actually, like, will stay at the hospital and continue to try to work on a placement. And that was pretty much it.
They always, as I said, they always find something temporarily. Even the foster home, the child, you hear of cases where the child is actually bumped from foster home to foster home to foster home in hopes of finding the foster home that's, in the best interest of that child, and so forth. So before I get to what happens to the in terms of the family and the child and their rights, let me just complete this 51B investigation. So if it was, again, the emergency, they've gone out in 2 hours, they made that determination, they called, supervisors, they got some kind of temporary placement for the kids, but they still have to come, finish a written report. So the 51B investigator, social workers have all different jobs. So this would be the 51B investigator. And he or she would probably do an interim report, like right away, within a day, and the final report, if it's an emergency, comes out in 5 days. Yeah.
Now, in an emergency investigation, is DCF required to take the child away, or can they use their discretion to
Again, we're back to the reasonable cause standard, and reasonable cause to believe that it first it started with the mandated reporter, and now the DCF worker. Reasonable cause to believe if the child or the children were to remain in that home, they'd be in danger of serious abuse or neglect. And it's nothing more than the police power of the state, right? The cases that you read, Prince v. Mass, the state's duty to protect children in spite of the rights of the family, because the family has custody at this point. Lester.
So does DCF have a list of emergency placement families?
Yes.
They can call
Yes.
and say, hey,
Yes.
you're on the list, you're
Absolutely.
willing to take a baby.
Yes.
We've got a baby that was in the street.
Yes.
Can we
That's exactly what
would
happens.
you come pick up the baby,
Yes.
or do we take you to...
Either or. Absolutely.
And
yes.
so then this gives the 51B worker time
Absolutely.
to investigate.
Yes.
And write a
yes.
report.
And write a report.
So
The
these
worker
people
is,
have been vetted already.
Exactly.
They filled out applications.
Yes.
someone has gone,
Yes.
interviewed
Yes.
them,
Absolutely.
and they're okay.
Yeah, quarried and all of that, and they're okay.
The
Yes.
state vouches for those.
That's
people.
why we mentioned before when Richard brought up, his situation, and I talked about, that they should go to family first. They're not gonna go to family first right away, because unless you can do the query and do all the checks and make sure family is
Right.
okay,
Yeah.
if it's an emergency, they might have to go to, temporarily first to, one of the foster placements, and then once that family is okay, then the child can be
Yeah,
transported to
because
the
a lot
family.
of times there's family members, but they're not.
They're not
clear.
appropriate.
No.
Yeah, they have
They may
backgrounds.
themselves be in the central registry
Yeah.
for,
Yeah,
past perpetrations
Yeah.
as well.
yeah.
Okay? So this worker is gonna, finish this written report. She'll have talked to all the parties. She'll have gone to the home, collaterals, school, medical, whatever he or she needs to do to come up with her final report. And her final report is, again, based on reasonable cause to believe that incident of abuse or neglect actually happened, and the decision is to unsupport if there's a lack of reasonable cause, or to support. Let me just back up. If it was a non-emergency, the same thing. The investigation still goes on, takes much longer. The final report in a non-emergency can be as long as 15 days. Okay, yeah.
In that case, does the child stay with the parent or
Yeah,
the
non-emergency.
caretaker?
Now,
Non-emergency.
yeah, you can have a family involved with DCF for years and never have any removal and never have any court proceedings. Okay?
Well,
Support.
something brought this child to the attention
Exactly.
of the reporter.
But it doesn't rise to the level, right, of we gotta take this kid out, or there's gonna be a whole lot of trouble, a whole lot of danger to their physical, emotional needs. Yeah, they're neglected. Yeah, they're maybe abused a little bit. We're gonna support and we're gonna offer services. Later on, when we do the medical neglect IFA case, we actually are going to conduct in class a hypothetical administrative review of a support decision. So the decision to support, again, can come about as a result of the emergency investigation under 51B or even the non-emergency investigation under 51B. And it's a longer, after that decision is made, remember I said before, the Administrative Procedure Act matters, and it's overriding because this is an agency. Say you have a family and it was a non-emergency, and it was they got notice, they let DCF worker in, they talked to the worker, and they said, yeah, I spanked my kid. Of course I did. And I do, whenever they're bad, etc. DCF decides to support, doesn't pull the kid because it's not really an emergency, but does support that instance of abuse. The parent says, I didn't want you in my home in the first place. I didn't want the state intervening in what I feel is right in terms of bringing up my kid. And I'm going to appeal your support decision. And you have the right to appeal it, and you appeal it to an administrative board, administratively. You've heard the term exhausted all administrative remedies in some of your courses that you read. So you go within the agency, and you can take it all the way up, or this way, from the agency to court, to a trial court, and ultimately, one of the cases that you're going to read, the Cobble case, the father did exactly that. He went to the agency, did the review. The agency still found for the agency. Then he appealed to the Superior Court. Then he went from the Superior Court to the SJC, appealing. And he had custody of his kid. In fact, the agency even closed the case. However, it supported that decision. And the dad didn't want that to appear anywhere. So he went all the way up to the SJC, and the SJC ultimately reversed, actually, the DCA. You'll read that later on in a couple of weeks.
what stage can the parents start the hearing process? I mean, they get taken away temporarily.
Yeah,
Is it
anytime, any
anyway.
decision, and it's the fair grievance process under and it's 110 CMR governs, as I said, the DCF regulations. Any decision, and not just DCF, I don't know administrative law that well, but any decision by an agency can obviously aggrieve a person, and that person has a right to appeal, right, that decision. And that's all it is. So where was I? Okay, so if it did get supported, remember the 51B investigator looked at the family and so forth. Still, that was, even though it took a while to investigate and to write, that still was just a very quick look at this family. Then the investigator does a longer look at the family called an assessment, and it could take as long as 45 days. After the assessment is done, then you have the first, and I'm sure you heard this term before, the service plans that DCF offers. So that service plan is within 55 days of the initial screen in. It involves DCF, having looked at, assessed this family, decided what the goal is for this family, decided tasks for, say it was domestic violence. And we'll get into that next week. Mom, throw the guy out. Sometimes as simple as that. Tasks, tasks for the child, tasks for the mother, tasks for the father. You'll go to AA every week. Obtain suitable housing. Goals for the foster placement as well. And then looking to the future, what can we do? Again, we're still trying to, visitation could be in that service, it should be obviously in the service plan as well. And every 6 months, if the child is in foster care for a period of time, the service plans are reviewed every 6 months.
Now, if they're in violation of the service plan?
If they're in violation of the service plan, and it's part of a care and protection case, the court would learn about that. Section 21A talks about reports to the court. Hold off, because I didn't get to the court process yet, but I saw another hand
So
up.
this process takes 3 to 4 months? 55 days, 45 days, 15 days?
Exactly. Now, you can have a quicker assessment, perhaps, and sometimes you do if it was an emergency situation. But the regs, the regs do say that somewhere, that you may see the assessment, but still 30 days, a month. You're right. And here's where it becomes tricky. So you pull the kids on Friday night. That means under 51B, was it C3, something like that? If I can find, I'll give you the actual section. 51B. 51, it's E. 51B, A, B, C, D, E, section E. Whenever the department has reasonable cause to believe that removal is necessary, it should take the child into temporary custody. So, we put the kids Friday night, all right? If the child is taken into temporary custody, the department shall file a care and protection petition under 119, section 24. And if you look at the allegations of 119.24, they're very, very general, and they include just about, any instance where a parent is temporarily unsuitable, and it's contained in the first paragraph of 119.24. And by the way, who is the petitioner? I keep talking about DCF. 119.24. And a person may petition. So really, anyone can file a care and protection petition. But typically, the cases that we read about have to do with DCF, the agency, alleging that the child, and then there's 4 instances, A, B, C, or D, without necessary and proper, and I'm reading right from 119.24, without necessary and proper physical or educational care, B is growing up under conditions that are damaging to the child's character. C, lacking proper attention. And D, the parent is unwilling, incompetent, unavailable. So those are the general allegations that would be contained in the petition. So the social worker would be going to court when? It was Friday night, on Monday morning, with the petition and an affidavit. You know, I was, contacted by officer so-and-so. I went to the home, described the home, the children were, blah, 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 signed on the penalties of perjury, blah, blah, blah. So the general petition plus the specific affidavit. Now, if you go to the third, I'll go back to the notice paragraph, and that's the second paragraph of 24. But if you go to the third paragraph of section 24, that's the emergency hearing. So that, again, the social worker is there Monday morning. No one else is there. Now, DCF attorney on call is probably obviously in the courtroom, but the attorney doesn't know anything, doesn't know that. It's the social worker that knows the case at that point. So what is the and what I'm referring to is right here, the emergency hearing, again, that resulted from taking this child or children under 51B, the emergency section, because DCF is then obligated to the temporary custody that resulted from Friday night's emergency nature is not going to last forever, right? They have to go to court and get a court order after that for custody. So the emergency hearing, anybody know what the standard is for that emergency hearing? And it's actually right in the statute. Didn't I say we're going to see it over and over and over again? Reasonable cause. If the judge, and it's right in, you going to read it to us, Lester?
Well, I'm looking at the safety of the child, the risk of physical, emotional injury.
11924, your third paragraph. If the court is satisfied, after the petitioner testifies under oath that there's reasonable cause to believe. Everybody with me there? Lester, where were you reading from a minute ago?
51B.
Okay. Yeah, we already did that.
I know,
okay.
I know.
So
You're too fast for me.
Remember, low level, reasonable cause, low standard. It's still an emergency. The kid is, in emergency foster care, or maybe by now with a relative. In any case, it's temporary, Still, we don't know what's going on with mom and dad in the home and whatnot. 99 point whatever times out of 100, the court is going to order temporary custody at that time. It's just reasonable cause to believe the children, if returned home, would suffer serious, physical, emotional injury, abuse, neglect, emergency hearing. And it's really, hearing is kind of a misnomer. It's usually just the social worker and the judge. As I said, DCF attorney might be there. I mean, you might have defense attorneys in the courtroom that are either on duty or on the list to be appointed counsel. Section 29 of the statute, by the way, is the right to counsel section. Remember when we read Galt, and we said that there was a specific decision that had to do with right to counsel for kids when their liberty was at stake. Well, states like Massachusetts, use that as sort of the beginning point for affording counsel in other areas. Why do you suppose that children and parents have a right to counsel per this statute when, I don't know, you don't have the right to counsel if Cassandra sued me?
Well, because both parties have their own individual rights. The child has his own rights and the parents have.
Yeah, but what do you have a right to counsel?
Because you guys
what
have
right do you
interests.
Yeah, you're talking about the different that you have to have different counsel, but just why does a child have a right to counsel?
Because they can't afford one.
But why?
Because they need someone to speak on their behalf, right? To
Child, again, can sue, can file a civil action, right? Superior Court for, an automobile accident. Child doesn't have right to counsel in that case. Why does a child have a right to counsel in a neglect and abuse case? Who was first? I don't know. Jadida?
Is it because the child is being protected from the parent in these cases?
I'm sorry, what?
Is it because the child is being protected from the parent in this case, so the parent really wouldn't be able to represent the interests of the child?
But that's not, again, you're trying to answer the same question Cassandra did. Just take it individually. Why do these people have the right to counsel? If I have a little too much to drink and get busted for OUI, the first time I go to court because my liberty might be at stake, is the court telling me you have a right to counsel, right? How is that similar, Patricia?
Because it's almost like their freedom is being taken away when they're being removed from their home.
Okay, expand on that.
So you have a right to counsel anytime that your freedom is being. You could possibly lose it.
Okay, in terms of the children now, it might be two opposing interests that might be at stake, right?
So they're keeping in their family with their parents,
Yeah.
and being removed to a different location.
Versus what else? What else might be the child's interest?
They want to stay with the parents.
Well, that's what Patricia was saying.
or they want to leave.
It's a child of the state as well.
Go ahead.
Well, so the state has an obligation to represent the interests of the child.
What does that have to do with the child's right to counsel?
Well, it's a fundamental right.
Why?
It's a constitutional right.
Can you show me where that is?
When?
Is the 5th or the 8th? I forget.
8th is cooler than usual much.
Right to counsel?
John?
Is it like
Jeremiah wants to see too. John.
Is it like due process, like a deprivation of life, liberty, or?
Well, that's what I'm trying to get at. What is it?
Well, they could go to the orphanage.
It's when the liberty's at stake.
The liberty's at
That's
stake.
when the right to counsel kicks in.
Okay, but what's the liberty? Is the liberty similar to Jerry Galt's liberty that was at stake because he was in danger of being confined somewhere till he was 18 or 21 years old?
Similar.
It is similar. Can you articulate what the similarity is?
Well, you would be being put in an institution or an industrial school like he was, but you would still be removed from an environment that you're familiar with, that you know, to one that's not known, and it could be punitive or restrictive. You don't know. It depends on where they're placed.
And you actually have, I think Lester got to the second one a little bit, and most of you discussed the first. So as the child, you're talking about two interests. One is your interest of remaining within the family unit, not having the state intervene, leave the family, alone. I have the liberty to remain within my family, go to my school, listen to the rules of my home, etc. But at the same time, I also should be free from abuse and neglect going to the state's intervention.
It's kind of different too with the Galt thing in the sense that if the parents screw up and the state wants to take the kid out, I would think definitely consultation kicks in because now you're threatening the liberty of the child for something they didn't do.
Okay, now let's shift gears. What about the parent? Because the parent also gets counsel under Section 29. What right are we talking about with respect to the parent's right to
I have the
counsel?
right to raise my children the way I see fit.
And again, does it fall within, as Jeremiah said, life, liberty, property, so that it becomes it does.
Yeah,
Yeah.
because no interference by the state, you want to be free of that.
Again, these early 14th Amendment cases that you read the first 3 weeks are the answer to these questions. So anyway, right to counsel. So I started this conversation when I was depicting, I guess, this emergency hearing. So at that point, it's the judge, the social worker that just put in the petition, the affidavit. As I said, the DCF attorney might be in the courtroom at that time. Will also, they'll will get a copy of, the petition and the affidavit. He or she now is assigned to this case, but it's the social worker that notes the facts. So the judge puts the social worker under oath. And again, if the judge believes reasonable cause to believe that returning the children would cause them harm, then the judge is going to order temporary custody to DCF. But that's not the end of that, of what other jobs that the judge has to do. So the appointment of counsel will happen immediately, counsel for the child, and we'll get to role of counsel questions and issues later on. But keep in mind, you might have many children with many different interests, so you might have more than one counsel for children. Same thing with parents. You may have parents with differing interests. So again, you may have counsel for mother, counsel for father too, counsel, you know what I'm saying. And the other thing that happens on that day, and this can get confusing, the court appoints an investigator. This is not the DCF investigator. This is the court-appointed investigator under Section 21. And that person is obligated to investigate the facts, go out and almost do a similar job that the DCF investigator did earlier, but that person is supposedly an objective, impartial arm of the court, okay, that's going to investigate and come through with a report. And it's that person plus the ongoing social worker that will be filing reports with the court and could become witnesses subject to cross-examination. And it's those reports that you see in a lot of the opinions that we'll read later on that sometimes contain hearsay and even totem pole hearsay that the court, that sometimes, and actually more than sometimes, becomes sort of an exclusion to the normal rules of evidence, because that person is subject to cross-examination, but also subject to, to objections based on the sources of the reports and so forth. But that gets into evidentiary questions that we get into later on.
In those hearings, is the right to counsel for everyone, or is it like in a criminal case where they're going to look at financial capability to pay?
Well, usually the court will assess for parents some kind of fee, and it's usually around $200-300. Now, certainly parents that are more financially able, and that, just like with the criminal cases, that don't want the court-appointed attorneys may end up getting their own, but they're certainly entitled to one under 11929. Now, again, walking away from that hearing is just the social worker. So parents under the section of the statute are now going to get notice. So they don't have notice now at this emergency hearing. Well, they know their kid's been taken. Hopefully, they know. But they don't have notice of this emergency hearing. What they're going to get notice of is the 72-hour hearing, the temporary custody hearing. Somebody had their hand up a second ago. No? Yes? Okay. So emergency hearing, just the custody order that comes out of the emergency hearing per the statute only lasts for 72 hours. That's why we call the temporary custody hearing the 72-hour hearing. Did I put it up here? No. Well. Okay. And that's the standard for the 72-hour hearing is not in the statute. And it's one of the cases that you have to read for Thursday. It's the Robert case. So we'll hold talking about the 72-hour hearing and what goes on at that hearing. But by that time, well, this is interesting because 72 hours is not a long time. Parents in the interim, again, would have received their notice, their summons, that a care and protection case has been filed. And by the way, the summons also indicates the worst possible scenario, that while this is a custody case, it could become a termination of parental rights. So right up front, the parent knows, what might possibly happen. They also get notice of, who their counsel is. But 72 hours is only a few days. So many times you'll see parties waiving the 72-hour hearing occurring within 72 hours because they may want the hearing, but really need to get together with their attorneys to decide, are they going to testify, what evidence they have, etc. Sometimes parties waive the 70, and they certainly have the right to the 72-hour hearing. And remember, the petitioner is DCF, and we'll talk about the burden of proof of all these on Thursday, but the petitioner is DCF, so they have the burden, and again, I'm for many reasons, parents sometimes waive the 72-hour hearing. And one of the most, I guess, popular reasons is they don't want to get out all the negative facts. And it's possible that they need the time. They need the time to, comply with the service plan, to get their act together, and don't want to put on the record because the minute you got, and most of the judges that start the camp protection cases usually retain them on an ongoing basis, usually. So the judge that hears the 72 will then hear all the status hearings throughout the final trial, the adjudication, the disposition, etc. So rather than have all the facts laid out in a hearing that lasts a day or half a day, they're just going to wait. They're going to waive it for that, because all DCF has right now is temporary custody. So if parents, through advice of counsel, realize that they're not going to win at the 72-hour hearing, why have DCF go through and air out all the stuff? So, you frequently see that and you say, oh my God, I can't believe they waived their right to hearing. They have the, but it does happen sometimes. Cassandra and then Jadina.
I have a question. The attorney for the child, is that the guardian ad litem? Or
No. And later on when we talk about role of counsel, we'll talk about the differences.
Okay.
But just keep this in mind. Massachusetts is a client-directed state. That means if you're representing children in particular, and we'll talk about maturity and the child, is the child, able to discourse with you about the course of action in the case and whatnot, you as the attorney for the child are obligated, especially if you're taking these cases from CPCS, you're obligated to have a strategy that is in accordance with your child's wishes, even if those wishes appear to be unpopular. We'll get into that issue with the child sexual abuse case. You frequently do see a guardian ad litem, be it for a child or adult, is a person that could be an attorney or a psychiatrist or some kind of healthcare, mental health professional that has been appointed by the court to sometimes investigate and write a report, and or at the same time to look out for their child's best interests and to actually report to the court what would be best for the child. Some jurisdictions have models of child representation being more guardian ad litem-like, if that's the correct word. Massachusetts, your counsel for the child, you're going to be advocating what the child wants. The 72-hour hearing, suppose it wasn't an emergency. Section 25 is also a temporary custody hearing that has the same standard. Suppose in the situation that I talked about before that you could have DCF, suppose DCF worked with a family for, 2 years and then said, forget it. We're going to go file a care protection case. They're not complying with the service plans, blah, blah, blah. Well, it wouldn't be a situation where they're going to remove the children right away because it's not an emergency. So they filed their petition under 11924 and then they'd have their temporary custody hearing under 11925. But the standard is the same as if it was the 72-hour hearing. They're both temporary custody hearings that occur, sometime after, but shortly after the petition's been filed. Let me just jump ahead for a moment to the final hearing. We'll talk about these more on Thursday as well. The final hearing is usually, obviously, sometime later. Per this statute, which was amended in '94, I believe. Per the statute, the final hearing, which is the trial, and that's governed by Section 26, has to happen within 15 months after the filing. Doesn't always happen. Sometimes they file, motions for continuances that get allowed. But in the old days, before this statute was amended, cases would sometimes just languish for years without going to trial. So this gets them in the system. The judges, the court personnel, everybody pushes. Either you're gonna return the children or go to trial. Trial happens, as I said, per the statute under 11926. Per the statute, within 15 months, and the adjudication phase of the statute deals with whether DCF has met its burden, and that's the first case you're reading for Thursday, Santosky versus Kramer, which is actually a U.S. case that set the standard for us at the trial. I'm not going to tell you what it is, but we'll discuss it on Thursday. If DCF meets its burden, that means that child that was the subject, or children that was the subject of this care and protection process, is going to be adjudicated in need of care and protection. So it's like when you find a defendant guilty, it's the adjudication part of it. After that is the disposition phase. So they could be adjudicated in need of care and protection, like in this non-emergency hypo that I talked about, and yet still be at home, yet still remain with parent, with, again, DCF overseeing everything. In most cases, it's adjudicated in need of care and protection, custody to the department is what you usually see. And in the worst case scenario, and I'm not going to get into Chapter 210 right now, they could be adjudicated in need of care and protection, and also the parents' consent to adoption be dispensed with, which is the end in terms of parental rights, unless you appeal, and win an appeal. If you don't have that worst case scenario, however, even though the case went to trial and department has permanent custody, you haven't lost parental rights. So the case remains open still in court. The case remains open still in DCF. So DCF holds, foster care review hearings, any kind of ongoing service plans, and court holds reviews. 29B is your annual reviews. Even under Section 26, suppose you lost a trial, and I don't know, you lost mainly because of your substance abuse issues. You were found, because the court found that you were currently unfit at the time of trial. But in 8 months later, you had more evidence that you were fit. You have a right to come to court for what's called a review and redetermination. So you could actually petition the court for custody back. Okay. So even though you lost here, you haven't lost parental rights. DCF still has its dual obligation, again, help the family, service plans, but still protect the children, unless and until the department moves or the court finds that parental consent to adoption should be dispensed with, and then you lose parental rights. There's one section that I didn't talk about. I think it's 29C. I could be wrong, but I'll get back to this. It's called the reasonable efforts requirement. And it used to come from federal law. Mass wrote it into the statute again in
What's it called?
reasonable efforts requirement. And what it means is whenever DCF goes to court for custody for removal of children from home, they have to certify ultimately the court has to certify. They have to convince the court that before taking that child or those children, that they've made all reasonable efforts to help the family and the children and keep the children within the home. Of course, if it's an emergency, if it's sexual abuse, any of the horrible circumstances, that they don't have to show that. The reasonable efforts is obviously not needed if it's an emergency situation. But if it's a situation where they worked with the family, but either way, the statute talks about the 29C certification. So the judge is always signing, and it used to be, as I mentioned before, it was from federal law, and DCF, then DSS couldn't get their federal money unless they certified that they had made reasonable efforts. Lester?
I was just going to say, res ipso loquitur.
Yeah, exactly. Yes.
The question I had before was about the investigation. Now, we know that DCF does their own investigation and the court sends an investigator.
Yeah.
Now, what happens if their reports are different?
Oh yeah, that happens frequently, absolutely. And they're both experts as defined under the statute 21A. So the 51B investigator that's citing on the part of the department is an expert. The court investigator who, 30 days later after she makes her investigation, recommends custody back to the parents, they're both experts and can both testify at trial or at interim hearings. Typically the court investigator does that one report, which is usually about a month to 6 weeks after they've been appointed. You sometimes see interim reports if the case has lasted for a long time, maybe closer to trial. The ongoing social worker, not to be confused with the initial investigator, is also going to be submitting. You have what's called status hearings, and I bet Patricia Jeremiah might have seen some of those where care and protection case is on for status, and everybody shows up, right? The social worker, the parents, the individual counsel for the parents, counsel for the children. By the way, children, and I forgot to mention this, in section 26, the first part of it, it says that the children are identified and then they're let go. So they're not physically in the courtroom normally, okay? And I say normally because in the sexual abuse case that we're going to do next week, the children, at least the two older ones, were always in court. But in the status hearings, the social worker that's working with the family will submit it's in the nature of a letter to the court, and it's an update. Since the last hearing, mom was supposed to come and visit and she didn't, or anything and everything that DCF wants to update the court about the family's situation. And again, as I mentioned before, there's sometimes hearsay in those reports as well. You frequently have motions in limine to exclude sometimes parts of those reports, especially when the sources can't be identified and things like that. Did that answer your, what question did you ask me when I rattled off?
No, it's okay. I just
don't
wanted
even
to know
remember.
what would happen, because I thought the cost investigator was sent out right away, as well as the DCF investigator. So now,
the 51B
days
would be
later.
done. And by the way, when you get to trial and the 72-hour hearings and whatnot, the 51As and the 51Bs come in, but they come in, as they say, just to set the stage.
Okay.
Not for that the facts were absolutely true in them. Patricia?
I have a question. So basically, the 72-hour hearing is to be sure that due process is followed, but it's
Yes.
really not to the family's advantage to take advantage of that.
If the facts are so against the family, and you have an absolute, just like you say to criminal defendants, you know, you have the right to trial. You don't even have to. But here's the other thing: criminal defendant doesn't have to testify,
Right.
And that's not. That can't. What's the word? Incriminate. Okay. The juvenile court can draw an inference of unfitness if parents do not testify. So there's no right that parents have in custody cases. You don't testify, it looks bad. So even though the burden's on the department, you don't testify, and it actually could become part of the judge's findings, fact, and ruling of law. You know.
But that's if you have the 72-hour hearing. If you don't have it, that's not an issue.
If you're exactly.
Okay.
But ultimate trial as well. All right, so we'll continue on Thursday, but I'd like to continue with the cases where we're getting into the court standards and whatnot. So if you could read the case law. And as I said before, we'll be coming back. I don't expect you to learn this statute just like that. I pointed out the most important sections of 119. We haven't really talked about 210 yet, and we'll talk about 210 more when we get to the adoption stuff.
It's Santosky is the first case.
Santosky is the first case.
Care of Robert.
Yes, yes.
Sandusky.
Yeah, I know.
He should be in trouble with children.